but while they do, I'll maybe give a little brief introduction. So, hello to everyone, and welcome to our webinar today on gender justice, thinking through the sex citizenship nexus in the Middle East. My name is Ashley Mantha-Hollins, and I'm a research fellow at and the Global Cit Coordinator at the European University Institute. So for those of you who are new to our webinars, Global Cit, or the Global Citizenship Observatory, is an online research observatory and network that collects and analyzes citizenship laws and electoral rights around the world. And we've been very much looking forward to this webinar, which is part of a series of webinars that we've been hosting over the year. And that looks at different aspects of citizenship law across various regions of the world. So our first session was in February, organized with Bronwyn Manby, who's here today, our regional coordinator for African countries. And it was entitled The African Union's New Treaty on Nationality and Statelessness, How to Make It Work. And you can find the recording of that on our Global Cit website. So today is our second webinar, and it was organized by myself and Thomas McGee, who is our regional coordinator at Global Cit for the Middle East and North African region. Thomas is also currently a Max Weber Fellow at the EUI, and his research is on the intersection of legal and social studies of the Middle East with a focus on Syria and Kurdish statelessness. We will also be hearing today from Professor Lillian Frost, who is an assistant professor at the College of Liberal Arts and Human Sciences at Virginia Tech, as well as an EUI alumni. Her research focuses on the legal and practice dimension of citizenship, and she has spent much time researching citizenship, migration, and gender in Jordan. Then we also have Dua Noureddin, who is working on her PhD here at the EUI, the intersection between statelessness and gender-based violence, with expertise on the Lebanese context. Finally, we'll also hear from Abdullah Yassin, who is an assistant professor in public international law at Erbil Polytechnic University, who has worked on issues of asylum, refugees, forced migration, minority rights, and he's also our Global Cit country expert for Iraq. So I'll now pass the floor over to our speakers. We'll start with Lillian, then Thomas, Dua, and Abdullah, who will each speak for about 10 minutes on the topic, and then we will open the floor for Q&A. Thank you so much. Up to you, Lillian.
Great. Thank you so much, Ashley, for organizing, Martin as well, and Thomas. I don't think I'll need the whole 10 minutes, but I'll give a little bit of context. So, as Ashley mentioned, my research focuses on issues of citizenship, particularly in Jordan. And historically, Jordan has had two main areas of discrimination toward women in its nationality laws. Um, One pertaining to women having to kind of follow or match the nationality of their husbands, and having issues of being able to maintain the nationality that they were born with. Those issues have been resolved and removed from Jordan's nationality law, most fully since 1987, but partially in the 1960s as well. And the other major area, and it's the one that I'll focus on, is women being unable to confer their nationality to their children, and also to facilitate the naturalization of their non-citizen spouses. And so this is the area that has not been reformed at all in Jordan's nationality law. And I should pause to note that these provisions did come basically verbatim out of British nationality law in the period when Jordan was a mandate under the British in the early 1900s. But while the British have removed these provisions from their nationality law, in the context of Jordan, they have not all been removed, and especially focusing on this issue of nationality conferral, and that only being an option, at least automatically and in most cases, for men. And so there are some slight exceptions to this in the Jordanian context, pertaining to in the case that a child would become stateless. But where this would most often come up in Jordan would be in the case of stateless Palestinian fathers, and Jordan does not recognize Palestinian men, Palestinians in general, as stateless. So Jordan recognizes being Palestinian as a distinct nationality, even though much of the international community does not. And so this kind of creates this gap for many children who are born to Palestinian fathers who do not hold an internationally recognized nationality. And you may notice that I keep leaning on using the term nationality. So in my research, I like to distinguish between the kind of legal citizen status, the legal documents that tie an individual to a state as just one dimension of citizenship. So while nationality is an instance of citizenship, I don't necessarily think that nationality encompasses all of the dimensions of citizenship. And this kind of comes out of my research in Jordan, where I often was made aware of a distinction between terms in Arabic for what I would translate as nationality, jinsiya in Arabic, and muwatana, which I would translate as citizenship. So you'll notice I make these kind of distinctions that some of my colleagues might not, and I'm just giving you a little bit of a sense of why I do that. Okay, so getting back to this issue of Jordan not allowing women to confer their nationality to their children and not to enable this facilitated naturalization to their spouses. So when I started looking into this issue, started looking at the academic literature on discrimination toward women in laws and issues related to being able to push forward women's rights reforms more generally, a lot of the existing explanations focused on, I would say, kind of three broad areas. Either issues with culture and religion, so having these like conservative cultural norms or religious norms that may be preventing women's rights reforms, which could include, as they pertain to women's ability to confer their nationality. Others had to do with the lack of women's political or economic representation. So, thinking about the fewer positions of leadership, political leadership that women occupy, then the harder it would be to advance women's rights reforms. And also issues of a lack of women's economic participation. So thinking about, maybe women not having as strong of a position economically in terms of earnings for the household. This could also make women's rights reforms more difficult. And then thirdly, issues of women's activism. So where there were not prominent women's activist movements pushing for certain rights reforms, then less likely to see them. And while each of these does, in a way, speak to the Jordanian context, it didn't really map on very well to the variation that I was seeing on this issue across the Middle East and North Africa, and specifically across Arab countries in the region, and specifically across Muslim majority countries in the region. There is a lot more variation than these existing explanations would expect, especially if we're kind of thinking about the role of, say, Islam in enabling this discrimination to continue. And instead, what I noticed as being more prominent when kind of looking across the region, and then especially thinking about the context of Jordan, where I had done all of these interviews and talked to people affected by and working on this issue, the issue of identity politics and concerns with demographics came out more prominently when focusing on this issue of nationality conferral compared to, say, other issues concerning violence against women and putting legislation in force to protect women from this, or gender quotas in parliament. Compared to these other issues, when I focused on nationality conferral, concerns about demographics were always at the forefront. And in the Jordanian context in particular, there was always this big concern about the number of non-citizen Palestinians in Jordan, and how, many women who were married to non-citizens who would be affected by women being able to confer their nationality, they're married to Palestinians. And so if Jordan went forward with reforming this aspect of its nationality law, then this would have major implications for Palestinians, for the issue of Palestine, for relations between Israel and Jordan, and these concerns that Israel wants Jordan to become this alternative homeland for of Palestine and for Palestinians. And so, like, this Palestinian issue was just intricately woven with the issue of discrimination toward women and nationality conferral. And it is perhaps not entirely surprising that this explanation kind of came came up in my research because when I started looking at the issues of discrimination toward women in nationality law, I was studying citizenship for, and broadly conceived, as I mentioned at the beginning of the presentation, for Palestinians in Jordan. And so the issues just often very much came up together. If one was mentioned, the other was, and vice versa. And so where my research is looking now, and what I'm excited to hear more about from our other panelists is, how well this understanding, this explanation that I've found in the Jordanian context holds up in other countries in the region, and perhaps not just regionally, but globally, since this is not an issue that is limited to the Middle East and North Africa, nor to the Arab world, nor to the Islamic world. I am working on kind of pitching fieldwork in the Bahamas and Barbados. My family is more excited about that fieldwork, perhaps, than going to Jordan. And so there's, I think, a lot of room for thinking about how these cases that are very prominent in the Middle East and North Africa, how they might speak to dynamics drawing from, colonial legacies, especially if we think about issues of nation building and identity politics, and who should be included, who's in the government that's defining national identity. So I think these are areas that aren't limited to the Middle East and North Africa. But I think I can roughly wrap up there a little bit under time. But again, kind of highlighting that what has come up in my research is this concern with demographics and these quotes. And I do have a PowerPoint. I can show some if there's interest in the Q&A from Jordanian officials, just highlighting that, we would be interested in having this reform. It would make us look better internationally, but we can't allow, this increasing to increase the number of Palestinians that hold Jordanian nationality, for these like big kind of demographic issues. And so something that also comes up, and see, I cannot allow myself to end early. I have to fill the 10 minutes. But these issues of securitization and identity securitization also coming up, like this elevation of the issue to this level of intense identity politics, and seeing maybe some parallels in other states that have large non-citizen populations across the region. So I think I can do it. I'm going to stop there at just about exactly 10 minutes. So thank you all for your attention.
Thank you so much, Lillian, for highlighting this really important relationship between citizenship and demographics. I'm sure, there's lots of really interesting cases out there, and I'm sure we can talk about it in more detail during the Q&A. So I'll pass the floor over now to Thomas. Oh, Thomas, I think you are.
Can you see my screen?
Yes, all good.
Okay, perfect. Thank you so much. And already I've seen a lot of overlaps with Lillian's presentation. So today I'm focusing on the Syrian context, and what I want to do is present a bit of background context on how these provisions entered Syria's nationality law. I want to look a bit at the previous efforts to reform the law, because I do think that they're very deserving of attention. And then towards the end, I'm going to be coming on to basically the question in my title, which is assessing change in the making, and what are the prospects of nationality law reform in Syria presently. So I've worked on this topic quite a bit as a researcher, and through that I've found myself entering into various advocacy collaborations with activists and those working on changing the law. At the moment, there's a lot of talk about a potential golden opportunity for Syria to finally remove this gender discrimination that prevents mothers from transferring citizenship to their children on an equal basis with fathers. So very much that's the same focus. I'm using the term gender discrimination in nationality law, GDNL, which is used in parts of the literature and sometimes even by campaigners. And that obviously refers to any asymmetry on the basis of gender in relation to nationality acquisition, transfer, maintenance, etc. But specifically what's in question with Syria, the main focus is on, similar to what Lillian was saying with Jordan, is a mother's ability to transfer citizenship to her children. This has been particularly a prominent question in the context of the Syrian conflict, when often children born to Syrian mothers find themselves unable to acquire any other citizenships or are potentially are at risk of statelessness if they're unable to access citizenship through any other means. So it's very much been framed as a women's rights issue, but not only a women's rights issue. In Syria, a lot of the advocates are presenting it equally as a child rights issue, as an equality and justice issue more broadly, as I'll come on to, a post-colonial issue, and particularly prevalent now is the question of whether this is also a transitional justice issue for Syria. So just to contextualize very quickly, here you can see in red the 24 countries where mothers do not have an equal right to pass on citizenship to their children with fathers, and approximately half of those states are in the MENA region, the Middle East and North Africa. Notably, some of those countries did, some countries in the region did carry out positive reforms in the 2000s, Egypt, Morocco, Tunisia, Yemen, and Abdullah's going to tell us about Iraq later. So if we come on to this question of how did this these provisions, this discrimination end up in Syria's nationality law, similar to what Lillian was saying for Jordan, there's a post-colonial, there's a colonial imprint in the history there. While for Jordan, it's British. In Syria, it's the French legacy. So we see here that we can trace back this gender discrimination within the nationality law, at least as far back as Syria's the first nationality law in the name of a Syrian state from 1925. That was while Syria was under a French mandate. We see here it's listed, sont Syriens. Syrians are les individus nés du père syrien, so individuals born to a Syrian father. We see pretty much the same principle, very similar language transferred into the first nationality law post-Syrian independence, that is from 1953. If we go on to the current nationality law, which itself dates back to 1969, which is already quite a long way back. So this law retains that principle on the primacy on paternal descent, and has very prevalent gender discrimination. It also combines that, overlaps with a new notion, a kind of pan-Arabic exclusionary identity. So we see here that the first means by which somebody acquires Syrian citizenship, so Article 3 here in this law, is where we find the main provisions defining acquisition of Syrian citizenship at birth. And point A is anyone born inside or outside the country to a Syrian Arab father. There are various other provisions that do outline some pathways through which mothers can supposedly pass on citizenship. It's all very conditional, and actually in practice, much of this is simply not applied in any case. So I want to very briefly touch upon this campaign that was run across the region in the 2000s in the name of Jensiti Hakli wa Usrati. My nationality is a right for me and my family. This was established as a regional campaign run out of the collective, run by the Collective for Research and Training on Development Action based in Lebanon. And they established this campaign across the Middle East and North Africa with a Syrian partner. And that Syrian partner was the Syrian Women's League, who themselves launched a campaign from 2003. We have a quote here from Sausan Zakzak, who's one of the pioneering activists with the Syrian Women's League, explaining how they first got into the issue. So she says that they were aware of there being an issue, but nobody had really looked into it. Sausan and her colleagues really went on to put this issue on the map in Syria. They launched this national campaign. They did research. They engaged with affected family members, raised awareness through the media, all these activities. They ultimately submitted several drafts to Parliament, petitioned the Parliament. And then I've done a lot of interviews with Sausan and her colleagues. The term that continually comes up is daraj, which means it was shelved. So all of these proposals were put on some physical or figurative shelf and just stayed there. They were never really, we don't know to what extent they were seriously studied, but ultimately nothing came of it. If we trace the trajectory of their work, they began with a very narrow focus. Here, their first study looked specifically at Syrian mothers married to foreigners. If you look at the study, it's specifically foreigners from other Arab states. So I think there was maybe a strategic element to focus on this, but what we see is as they went along, they increasingly looked at families where the father was stateless or missing, or a child was born out of wedlock, and they really expanded this towards what I go on to call a more intersectional solidarity through wider citizenship campaigning. So I think there's also an intersection with what Lillian was talking about there. So we see those who were campaigning on reforming the gender discrimination in the nationality law, they got to a point where they weren't seeing it in competition with other groups excluded by the law, by the nationality law. For example, here, they've made a very direct pledge and commitment of solidarity with stateless Kurds who've long been excluded. So we see this intersection. One other really important thing they did within their work is they systematically began addressing all of the pretexts that were often used, very much in line with what Lillian was saying, securitization, but also the demographic arguments. So one topic that often came up for them was, well, maybe this is not acceptable under Islam. They very proactively went about addressing each of these issues. They got the Grand Mufti at the time to make a statement saying that Islam presents no impediment to this. It's a separate issue. They addressed that. The issue of the intersection with Palestinian rights to the right to return to Palestinian historic homeland. They got various key Palestinian figures to state that that's a completely independent right in international law. So they addressed all of these things progressively. Within the conflicts, it got a lot more complicated as foreign fighters were entering the country. So that really put a hold on the progression of the campaigning. So if I'm going to really, really quickly skip to what's kind of the current situation, but even before the fall of the Assad regime in December 2024, one of my colleagues had written about the importance of addressing gender discrimination within a transitional justice framework. So she'd argued that, yes, all of these exclusions predate the Syrian conflict, but they need to be addressed in the transitional process, that transitional justice process that is ongoing now, because in many cases there are intersections with conflict-induced harms, forced displacement, families who've not been able to register the birth and establish the paternity, and the child is living with a mother who also can't pass on citizenship. So this was stated pre-conflict, But one of the things that has happened recently is I was involved in a conference that was held in Damascus University that very much put this issue on the map. It's a conference that we organized with a civil society organization I belong to, Hawiyati, with UN Women and Syria's National Commission for Transitional Justice. It was in many ways, I think, quite successful in the fact that it was covered in quite widely in the national press, faithfully according to the messages that were being presented at the conference. That's not to say it was without challenge. At the moment, we've also simultaneously been working quite closely with a series of the MPs to work on kind of capacity building, because ultimately it's the MPs who will pass any legislation. That said, as yet, the parliament hasn't been fully reactivated since the fall of Assad. There's a number of MPs missing. We're still awaiting presidential appointments. So there's lots of obstacles, again, around demographics, around sensitivities, various pertinent questions of strategy, how best to approach this. Is it better to do a quiet campaign as opposed to a media campaign? Prioritization of the issue, I think, is also quite a challenge. And one thing that we did see, if I just skip to maybe this can be my final slide. Again, another colleague has, actually the same colleague, Tawil, has highlighted this notion of kind of this problematic implicit assumption that justice can be prioritized. So we saw there was very positive engagement at this conference, both by those there and generally by media. But a lot of the social media commentary really focused on what does this have to do with transitional justice if one of the actors involved in hosting the conference has a mandate of transitional justice. So it seemed that in many people's views, this is not a priority transitional justice issue. So my colleague here has been writing on a counter argument that if you don't have citizenship on an equal basis, you don't have a solid basis for any transitional justice that's fair and going to serve everybody. So I would encourage anyone who's interested to maybe read her article on that. And I think I can stop here.
Thank you so much, Thomas. That's given us a lot of food for thought and already sparking some questions in the Q&A, which is great, or in the chat, sorry. So now I will turn the floor over to Dua.
Hello. Okay, I'm just gonna share my... I think there's an issue. I'm just gonna try to share it again. I'm so sorry. I'm just gonna try to share it again because I had shared it at the beginning and it worked, but now it doesn't show. Okay.
Yeah, it was working before. That's funny.
Yes. Does it show now?
Perfect. Yes, you're good.
Perfect. Okay, thank you so much. And sorry for the glitch. What I will be sharing now is basically focusing on Lebanon. There's a lot that has already been highlighted because there's a lot of commonality, but I will now just try to highlight mainly the case of Lebanon. To begin with, the idea is that when talking about the case of Lebanon, we cannot really talk about the nationality framework without talking about the colonial origins. The legal architecture that governs basically who is Lebanese and most importantly who is not was constructed during the French Mandate period, and that has remained virtually the same, especially since 1943. So understanding its operation requires us to basically understand four decisive moments To begin with, in 1920, France basically established a Greater Lebanon under the League of Nations. What it did in particular is that it brought together a very heterogeneous region that is basically made up of Christian Maronites, Orthodox, Sunni Muslim, Shia Muslim, and Druze under like the same state in a sense. And what it did in particular by doing that is that it also divided power based on each person's sect. So religion from the get-go was very much embedded in the way this governance would come about. And it pretty much laid the groundwork for a very sectarian political architecture. Now, in 1925, the higher French commissioner basically issued Arrêt number 15, and that basically codified the Lebanese citizenship along patrilineal lines, which basically means only fathers can basically transfer like nationality and women cannot. And the idea is that this was not an oversight because it's something that reflected, first of all, the French colonial legal system and also the 20th century European jurisprudence. And what's most interesting is the durability of this logic that has started then and remained till now. Now, in 1932, France basically conducted a census in Lebanon, and it's the only census that we basically have that was ever conducted. And the results that were obtained, just to clarify that the consensus was basically done demographically based on like a person's sect. So the results of that basically underpinned the National Pact. Basically, the sect that was like dominant would have, in a sense, more power within the state. So based on the results that we have obtained from the consensus, what was agreed on is that the president in Lebanon would be a Maronite Christian, the prime minister would be Sunni Muslim, and the speaker of parliament would be Shia Muslim. And this basically not only underpinned the National Pact that basically took place in 1943, but has been the only census that was developed and something that has frozen since. Now, in 1943, there was the Lebanese independence, but what is most interesting is that Lebanon basically bought in wholesale the 1925 nationality decree. And in a sense, the gendered framework that was developed early on became entrenched in this new independent state. Now, the core asymmetry when it comes to Lebanon's nationality law can be stated simply. Lebanese men can transmit their citizenship to children and spouses, whereas Lebanese women cannot. And this matter is not like an administrative, it's not only a matter of administrative practice, but it's something that is actually embedded in the 1925 decree itself. So I have put basically some points here to note what women and men are able to, and I want to highlight a few things. By law, Lebanese men can pass nationality to their children who are born in and outside wedlock. They can naturalize a foreign spouse within 1 year of marriage. So basically after marriage, by 1 year, they can apply and then gain citizenship. They can confer the nationality to their children, even if their spouse is actually stateless or foreign. And they basically can maintain nationality regardless if they have residence abroad. Now, for Lebanese women, they cannot pass the nationality to their children who are born to non-Lebanese fathers. They cannot naturalize their foreign husband or somebody or their spouse who is stateless. They cannot secure Lebanese identity for their children, independent of paternity, but this I will say to take with a grain of salt because I will highlight or I will focus on in a bit. And they cannot also transmit citizenship even if the father is stateless, as mentioned, deceased or absent. Now, in Lebanon, there are a few exceptions when it comes to women and basically passing on their nationality to their children. In cases where they can prove that the person or like the spouse is unknown or absent, in very specific cases and through very complicated procedures, women can actually confer their nationality to their children. But how do they do it? They register them on their name. But what that actually means is that this is visibly telling this is putting it out there that the woman doesn't know who her spouse is. And that puts her under a lot of social stigma. And it's not only social stigma for her, but also for her children. And apart from all of that, the stigma that she would experience would also be through the legal procedures that she would have to go through. Now, some women have actually done that in cases where their spouses are stateless, but it is again very complicated and it's not always very much like doable. Now, in the 1932 census, it wasn't only women who are in a sense excluded in terms of citizenship transmission, but it was also another communities like the Kurdish community who were before 1925 and even had also moved at one point after 1925 to Lebanon. They were excluded. The Dom community, which are a semi-nomadic community, were also like marginalized and excluded from the 1932 census, and the Palestinian refugees. And the Palestinian refugees specifically had two justifications, which were already like highlighted by Thomas and Lillian, which is that, first of all, I think mainly Thomas, there was the idea, first of all, that of course they didn't want to take their right of return. So this, by basically keeping them as stateless and within that status, would actually mean that they would have the right to go back. And the second reason, which is very, very essential in all of this aspect in particular, when it comes to passing citizenship, was the idea of demographic balance, which I will even describe further more in the coming slides. Now, when it comes to the topic of passing or transmitting nationality, the main core argument in Lebanon has always been that in doing so, we would be, if we give women the chance to pass their basically nationality to their spouses or their children, we would be tipping the balance that this very state was built upon. What does that actually mean? The idea in 1932, when the census was actually done, the results showed that the dominant sect, or like the highest percentage, were Maronite Christians. Now, there are a lot of arguments and even research that say that even that back then was not really accurate because of the methods that they have utilized. But what that actually means is that the Christian Maronites would have most power. Now, if they are to repeat the census and there is a majority of Muslim, then there will have to be a different change in how power sharing is. So the idea is that we don't want to allow that, because there are a lot of like Palestinians, for example, who are married to other Lebanese people and who are also Muslim. So if we actually permit, in a sense, we permit that they actually are naturalized, or these foreign spouses for women in particular have the nationality, then we would tip the balance. Apart from the fact that there's no plan for a second census, and most importantly, there's a flaw in the logic in itself. So if a Lebanese person marries a foreign woman who happens to be Muslim as well and passes the nationality, that's also an addition to basically the population in itself. But these are a lot of obviously the logic in itself is flawed, but there's also another important aspect that a lot of feminist and legal researchers have also highlighted. There's a specific quote that I really like because it explains well the situation in Lebanon. A researcher called basically Lamia Shhade, who spoke that a woman's nationality in Lebanon is not her own. It is borrowed from her father, transferred to her husband, and denied to her children if that chain of male descent breaks. And the idea that they highlighted, apart from this notion that was always used as keeping the balance, there are a lot of issues that have to come with this idea of patrilineal citizenship, because what it does is that it constructs women as reproductive vessels of the national community. They're not citizens in their own right. So this also produces structural inequality beyond the legal domain in terms of social recognition, in terms of property rights and political participation. Now, what is most relevant in terms of a concept in the case of Lebanon, and what in a sense offers the most specific theoretical framework, is a concept developed by Maya Mikdashi, which is titled or noted as sectarianism. So Mikdashi's argument is that in Lebanon, sex and sect are co-constitutive categories of legal subjecthood. So one cannot understand how sex operates in Lebanon without understanding how sect also operates, and vice versa. So the citizenship law is primary example of how this basically takes place. Now, an example we can actually think of is the idea of a Lebanese woman who wants to marry or marries a Palestinian man. She's not in a sense here asserting only her citizenship right, but she's also in a way the confessional arithmetic, like a potential vector of demographic change that would threaten this sectarian balance of power. I have also brought in some scenarios just to briefly give something that is more clear, because the idea is that when we talk about legal asymmetry, it sounds something abstract, something from 1925 that is just there. But the idea is that it also has a lot of devastating consequences. So, for example, a stateless woman who would want to have citizenship might go through the process of marriage to get like a citizenship, marrying somebody who has citizenship. And the idea is that she enters into negotiations from a position of structural vulnerability. The prospect of getting like legal status can compel her to go into a union that she does not want or remain in it. And also that puts her at the like risk of coercion exploitation, which is basically a pattern that has been documented. Now, with the idea of Lebanese mother and foreign father, children of basically that union, what happens is that they become strangers in their own country. Apart from the fact that they cannot access public services, when they become adults, they can actually be deported. And then the idea of the absent or deceased father, we have basically touched upon it a bit. But basically what happens is that in cases where a woman cannot basically confer the nationality by using these loopholes, children would become stateless, and that would be passed on for generations. So the idea is that Lebanon's also refusal to conduct like a new census in 1932 is explicitly linked to fears of naturalizing children of Lebanese women who are married basically to foreigners, but in particularly Palestinians who are Muslim. And that would also alter the sectarian ratios as we have highlighted before. So what happens is that a woman's right basically and her citizenship right becomes hostage to these sectarian political arithmetics. Now, while this is an issue that has been going on for a very long time, there have been a lot of like advocacy and reform efforts that have taken place. There's obviously much more than the ones that I have here in the slide, but I've only highlighted a few. So basically, from the 1994 until the 2000s, there was a collective for research and training on development action that basically first developed this advocacy campaign for women to be able to pass on their citizenship to their children. Then in 2009, what happened is that there was a bill that was introduced also to basically allow maternal transmission. It passed through the committee and made it to the parliament, but then it was stuck there due to sectarian, objections, and again, about the balance. In 2013, also the Institute for Women's Studies in the Arab World, they did a very comprehensive research talking about the risk of this type of law being still available, as it risks basically over 78,000 children of being stateless. In 2018, the Human Rights Watch, they also published like a report called I Lost My Dignity, and it basically compiled testimonies of Lebanese women whose children were basically denied nationality to try and amplify more international backlash and pressure. And then till now, there are also a lot of efforts that are happening, but a lot of the justifications that are utilized is that first, like in the 2000s, there was like the economic crisis, then there was COVID, and there was paralysis of the government, and now there's currently war. So all of that basically put this type of issue at the very back of priorities. Now, I just want to note something like on the side is that obviously the law is what has been impeding this process for impeding women from being able to pass nationality, but it doesn't like operate on gender alone. It intersects with a lot of with the confessional system, with class inequalities, with even racialized hierarchies. So for example, when it comes to like class and documentation, certain women who are wealthier usually find can navigate different ways to ensure that their children can have actually education because they can get private schooling. They also navigated through residency permits, through getting certain connections that would enable their children to have at least more a better life than others. And obviously, with the case of the kafala system, which is the sponsorship system in Lebanon, it ties migrant domestic workers to their employers. And what happens is that in case a child is born to a Lebanese father and a migrant domestic worker, even though by law this person is allowed to basically have citizenship, the social stigma and the legal, they would still face social stigma and legal complexity in obtaining it. Because social stigma doesn't only function in everyday society where a person is trying to get their basic needs, but also even in the legal systems. So there is a lot that has been done in terms of advocating. These are some of the main outputs of reports that were basically put out that basically state what is actually needed for us to have equality in the law. I'm not going to go over them, but it's just mainly to begin with by working on the law in itself. There isn't much that I would conclude with, but just the idea that there is a lot being done now, and like this is not something that has been stopped, but it has been like a complex and a very long battle that has been going on for a very long time. Thank you.
Thank you so much, Dua, for this very excellent and comprehensive presentation on the Lebanese context. So I will now turn the floor over to our final speaker, Abdullah, who will share with us the context in Iraq.
Thank you so much, Ashley. Thank you. Thank you for having me. Thank you all, Thomas, Lilian, Dua, Martin, Maya, who's sending all these emails. Thank you so much. It's pleasure. My talk will focus in the next 10 minutes looking at the difference between what is in the constitution, what's in the law, but what's also looking at it from administrative practice and how this gender discrimination balance works. The points I would outline, of course, has been also, as Dua was saying, there is so much commonality between what we are saying, me and the rest, because there are also resonates in other regions. What I can say that the Iraqi nationality law 2006, it's quite, if you look at compared to other nationality laws, they're quite progressive, and that brings into that. Of course, there are some criticism of that. And that's what I would like to highlight in the next 9-10 minutes. In terms of the reform that took place actually in 2006, that's what I wanted to do, how the Iraqi mothers transfer their nationality to their children. I also wanted to look at, for example, how this administrative practice looks at the difference with the legal interpretation. And that continues to be the unequal outcome between man and woman. So the debate that I will look at also more specifically is the Article 18 of the Iraqi Constitution, but also Article 3 and 4, which is there in clash of the nationality law of 2006. If I just give you a bit of a background in terms of the Iraqi nationality, prior to 2006, the Iraqi nationalities mostly focused on the demography, on loyalty towards Ba'ath party members, on linkages to the parents, but most specifically to the father. And if you look at the 1963, but even before that, the prioritization was on parental link on the national transmission. Iraqi fathers could automatically obtain the transfer of nationality to their children, where the Iraqi women faced major restrictions, containments towards that. So this kind of women who married, for example, to foreign nationals risked complications of concerning their own nationality, but also the nationality of their children. And the quote that Dua gave was perfect to this context. But also these provisions also reflect the broader regional attitude towards the link in nationality, loyalty, and demography that we have in Iraq. But if you move away from the pre-2003 to after 2003, you will see that there was a move away towards the more discriminative nature of Ba'ath policies into more alignment towards the equal setting between man and woman. But of course, what I will talk about, there is still some structural gender discrimination or inequality, in particular the administrative practices, what is there in law, in practice and theory, is what is there in law. It's very different than what's there in practice. But if you look at the Article 18 of the Iraqi Constitution, it makes it very clear that anyone born to Iraqi father and mother is Iraqi. And this is really helpful because it's very explicit into terms of that. And in theory, it sounds beautiful. It means that the Iraqi woman should possess the same right as the Iraqi man. And the constitutional reform was widely regarded, of course, as I said, as progressive towards the nationality law. However, the constitutional equality has not been fully reflected in the structural implementation of the current Iraqi nationality law, as I said. And in practice, if you look at the Iraqi authorities frequently treat nationality claims through mothers differently from those through their fathers. And the constitutional guarantees, for example, therefore remains partially undermined by administrative procedures, as I said. So what what is the gap there is the gap between the constitutional right and the practical implementation. And if you, the prime example is the Article 3 and 4 of the Iraqi Nationality Law 2006, number 26, which Article 3 provides that children born to Iraqi father automatically acquire Iraqi nationality regardless of place of birth, even if that child was born, let's say, in the UK, in Italy. You guys are in Italy. In Italy, that person is entitled to the Iraqi nationality law. Well, this is not the case in our Article 4. Article 4 states that children born to Iraqi mother and foreign father may acquire Iraqi nationality, while the Article 3 establishes the automatic nationality. The Article 4 often requires administrative application, approval, documentation, procedure. And these two distinctions of Article 3 and Article 4 within one nationality law creates an equal treatment between the parental and material transmission of nationality laws, as I was mentioning. And in practice, we can see that I will give you examples in the coming up slides. You will see that such issues does occur in day-to-day life. And many even Iraqi embassies and national directorates here inside Iraq continue to request additional procedures for children of Iraqi mothers who born to foreign father. And that problem frequently arises, especially when the fathers maybe lack documentation, if he was a refugee and a statelessness, or if the person is from another country. Or refuse, maybe they have the cooperation. I can give examples of Iranian or Turkish who have came to this country a long time ago they face this issue. So this kind of what happens, it delays and prevents nationality recognition for children who should legally qualify as the Iraqi citizen. So this distinction between the automatic apply with the conditional through mother creates an equal, as I said. And I will give you an example of a video. So for example, we interviewed, I think this is also, I've done a research with Thomas, that we looked at for example, in terms of how families can acquire Iraqi nationality, especially refugee families and families with the statelessness. Have these similar issues. For example, a family I interviewed where the father was actually from Turkish national, came to Iraq in 1984. Of course, he's a stateless because he has lost all the connections to the country of origin, which was the Turkey, and he's been living in Iraq since 1984, who's not entitled. Of course, all refugees are not entitled to Iraqi nationality. There are some certain with the issues of who enter Iraq and how they enter Iraq that can apply. And for example, he had 3 children. 2 children were able to acquire actually the citizenship, where the 3rd child could not obtain, and that created obstacles in terms of the access to education, to healthcare, to travel, and to freedom of movement, as I was saying. And what we found out is actually this was not a case in isolation. There were a number of other cases where similar thing has been happening, where also we found out there are people who are paying up to $10,000 to get the passport. So if you have money, you can get the citizenship. That has also happened. What we had actually recently, I say recently, but 6 years ago, is the Iraqi Federal or Supreme Court actually in 2018 decision where issued that the court emphasized that the nationality provision must be interpreted constantly with the Article 18, which recognizes citizenship through their parents, either parents, mother and father. And that is actually a ruling has become an important reference point in legal scholarship in terms of because what we have is this criticism between the discrimination between the two. So the decision was significant. Why? Because it reaffirmed the constitutional equality principles regarding nationality transmission. But also, as I said, in practice, it creates a bit of issue. And if we go one step further, you can see that this is also issues for people like in terms of the refugees and statelessness. Gender discrimination, nationality, or intersect strongly with the communities of displacement and statelessness refugee married to a foreign or undocumented man often face particular difficulties securing nationality recognition for their children. And we have at the moment, even in the KRI, not just 100 but thousands of cases like that, and especially cases of some of recent as Syrian refugees who have been in Iraq since some in 2004, some in 2011. So some families, as I say, eventually, what do? They leave and they go to a third country, which is living here because of lack of that. So I would like to conclude because I'm seeing Ashley's face. So here is like the conclusion. What I want to do is that the Iraqi national law presented a significant improvement, of course, to the earlier versions of which was looked at mostly the father, mostly demographic, mostly a bit gender-based, but also a bit of discrimination because of the Ba'ath Party pan-Arab assumption. But now we are going, mostly there are also recognition towards mothers. But the problem now still we have, if those children are to marry to a foreign father or to a displaced or to a refugee, we still have this reform has to change. And the substantial gender discrimination concern, as I said, remains. And the distinction between Article 3 and 4, I still do not understand why these two articles, if I put me in the next slide, why these two articles are not combined, not combined or not put it together. Why? Because it will also it makes it and the word of condition can be removed toward automatic nationality law. This also simplifying the procedures, reducing administrative discretions, where some administrative discretion in Erbil, where I am here now, can be different with somewhere in the Naino Innus, with some in Basra, with some in Baghdad. The procedures are from one governor to another governor, it's quite different. An Iraq case actually demonstrates legal reform alone is insufficient unless it's accompanied by effective implementation and institutional change. So that what is happening there can also happen here. And the final thing, that citizenship is not only a legal status, but also a question of belonging, because as I ask that to a person who has been in 1984, where do they belong? Because it's part of their identity, their rights, and also participation in the society that they are from. Thank you so much, and I'm looking forward to questions.
Thank you so much. Thank you to all of our speakers. A round of applause to everyone. We have just a couple of minutes for Q&A because those are all such rich presentations. We've sort of run the clock. So maybe I'll take 3 questions and then I'll give each of our speakers a sort of chance to a minute to say some words, and then we'll wrap up. So I'll start with Bronwyn and then go to some of the questions in the chat. So Bronwyn, go ahead.
Hi, thanks very much. I was just typing again and then thought it was quicker to speak. I was wondering thank you first for all these really interesting presentations and sort of tour of the region. I was wondering if we could look to the other end of the telescope. Are there any good practices you can see? And I'm meaning more at the administrative level than the legal level. The legal analysis is clear that we have ongoing issues and for all the usual reasons. And I'm thinking especially of the post-conflict societies, so Syria, Iraq, Lebanon is not, it's a different type of conflict, and Jordan is also very much conflict affected. But what are there good practices in relation to trying to determine the nationality of people who are affected by gender discrimination or by discrimination on sectarian basis in general, in relation to affirming, getting recognized, or acquiring citizenship? And I'm wondering, for example, in relation to the treatment of identity documents issued by the various independent or quasi-independent Kurdish regions. Are there any good practice? I'm aware that, of course, there's massive amounts of discrimination that would against those groups, but are there any good practices to say that actually you can see that there's some common sense being applied here in terms of trying to resolve the status of some of the affected groups?
Thank you so much, Bronwyn. And I'll just read a couple of the questions out in the Q&A and then give the floor back over to our speakers for their response. So We have a question from Martin, directed to Abdullah. So he says, very interesting. How much do the existing challenges in Iraq on gender equality and citizenship reflect the political context of the 2005 Constitution example post 2003 US-led invasion? And then Brownman had another question about the relevance to national policy debates, if any, of the various Arab League normative statements on nationality. In general, in relation to gender discrimination in relation to the Palestinians. And then Michael asks, what have been some of the reasons given for confining citizenship transmission to children, to fathers, males, and excluding mothers and females? So why don't we go back in the order that we started with, and I'll give the floor to Lillian for a minute, and then Thomas, Dua, and Abdullah, and then we'll finish for the day.
Hey, thanks, Ashley, and thanks for everyone's attention in the audience. And the presentations were great. I was scribbling down notes, and I have many questions that I will follow up directly after the webinar for the other presenters. Okay, quick answers for Michael's question about limiting conferral to men. I do see often there is this leaning on cultural explanation. So referencing Islam and the blood passing through the father, even though, as Dua pointed out, and or maybe it was Thomas, that you can kind of make the case that this like secular national identity is not related to religion, but often that is referenced, Michael. Sometimes I've also heard a reference to kind of international norms, path dependence, like that, all of most countries in the world, if not all, had these provisions at one point, and then there's this issue of when they go away, and then that can immediately link to talking about the political. So I would say in my interviews, either it's a discussion of the cultural or it's a discussion of the political, and especially the Palestinian cause, that it's many times has been put forward to me, and recognizing my positionality as a woman, that, oh, this isn't a gender issue, but it's a political one. Of course, it's a gender issue as well, but Michael, to give you a sense of those answers. And then for Bronwyn's question about the Arab League statements, I would say in general, they don't have that big of an impact in Jordan. And I think this is because on the one hand, there's a lot of kind of conflicting statements if we're looking more broadly at the Palestinian issue, in addition to the concerns about nationality conferral. And so at the end of the day, Jordan will kind of always fall back on this issue of needing to defend the Palestinian cause and to prevent Jordan from becoming an alternative homeland. And so even if you kind of present some crystal clear writing about the need for nationality conferral, equality across gender, there's always this aspect of Jordan being different. Jordan is positioned differently than other Arab states because Israel is trying to convey Jordan as this alternative homeland for Palestinians. So I would say that a simple answer would be that actually, it's a complicated answer. It maybe plays into some of the justifications in a way, but at the end of the day, Jordan's always kind of putting forward this alternative homeland narrative. And 1 minute wasn't enough, Ashley. One last thing to note, and this ties into Bronwyn's last question, is that we could make the case that these kind of international pressures, probably less so from the Arab League and more from the EU or the US, have had some impact on Jordan, because Jordan introduced a set of privileges and special identity cards for the children of Jordanian women married to foreigners. And so while touching on Abdullah's presentation, there have been issues with how well it has been implemented. The Jordanian government did put into writing, not at the level of law, at lower legal levels of more like executive decisions, certain rights that for these children to access. So in practice, in a way, if we want to kind of spin it positively, there's been some recognition of the everyday challenges that these children face. And in realms that are considered somewhat less political, there's been kind of some movement in trying to facilitate their lives, though it's been a bit uneven. So I'll stop there.
Thank you so much, Lillian, and Thomas, just with some brief final remarks.
Okay, I'll respond in the same order that Lillian addressed the questions. So first of all, on Michael's question, If we look at the responses that the Syrian government has given in Universal Periodic Review responses, there are 3 points that they have put on the record. The first is the Palestinian issue, and they cite UN General Assembly resolutions. Arguably, that's potentially a misreading of international law. Many international lawyers would read. The second point is they've cited how Syria is extremely geopolitically and strategically important in its location. Not exactly clear what they're getting at, but sort of hinting at some kind of vague demographic sensitivities in that one. The third point that they have mentioned is a desire to avoid dual nationality, because there's some sort of underlying assumption that that's a bad thing, and that causes sort of split loyalties. So those are the 3 that the state has given officially. In response to this conference that we held back in March, we did a bit of an analysis of the social media response. Interestingly, one of the things that we saw more than anything was people saying nationality is transferred from men, as if that's the way it's always been, so that's the way it must be. That seemed to be what a lot of people were getting at on social media. Bronwyn, on League of Arab States, very little relevance to Syria, partly because Syria had suspended membership from 2011 to 2023. But more broadly, I think the Arab League documents have unfortunately not been socialized particularly well. I'm yet to come across a state official that's not in extremely close proximity to the League of Arab States who's actually heard of the Arab Declaration for Belonging and Legal Identity. People in ministries of interior, even those who've attended these sort of international law conferences sponsored by UNHCR, etc., they're not aware of it as even existing. Good practices, certainly there's some good practice on flexibility when it comes to accepting different kind of documentation, forms of documentation, accepting witnesses in place of documentation sometimes. With the Kurdish community in Syria, there have been some recent developments that potentially are positive. There was a decree passed at the beginning of this year to opening up the potential to apply for nationality for stateless Kurds. It remains to be seen how well that will be implemented. I'll stop there.
Okay, thank you. And Dua also with some brief final remarks.
So a lot of the things that were already mentioned basically apply also in this case. I just want to talk about the case of Lebanon, because when I was talking about the division of basically the sectarian power, it also has to do with something that we now have, which is the personal status law. So the personal status law, which basically means that a person based on their sect have a different law that basically manages everything about them, is something that is very much important to talk about, because that basically means religious courts still have a lot of power in deciding things that have to do with nationality. Of course, as we mentioned, there was a lot of conversation on like the balance and whatnot of like the sectarian balance and all of that. But it also has to do with the idea that religious courts still have a lot of power in deciding. And this has something that has been used as a justification to basically not, regardless if it's something that is in religion or not. Now, there are a lot of projects that are being done that are trying to also address these religious courts, but there isn't much like top of my head that I can now mention, apart from the organizations that I highlighted before. There's Frontiers Ruwad, who are doing so much to try and actually like address the roots of this issue in itself before even taking it as like to the basically as taking it to the government.
Thank you so much, Dua. And Ajla, maybe you could take this final question from Martin, and then we can end the session for today.
I think just to answer Martin's question, the answer is yes, of course. The existing challenges in gender inequality in Iraqi citizenship law strongly reflects the political context of the 2005 constitution, especially the post-2003 transition. The Iraqi citizenship equality challenges actually reflect the post-2003 constitutional compromise. For example, where we talk about democracy, federalism, Islam, identity politics were negotiated under the occupation of U.S. occupation, and also the instability in across the country. But what I can say, although the 2005 Constitution introduced equality principles, political compromise, left things like what Dua just said, personal status, nationality, family law shaped by religion, patriarchy, and sectarian bargaining. So, gender inequality in citizenship is not only a legal issue, it reflects the unresolved tension of Iraqi post-2003 state building process, of course.
Well, thank you so much. And thank you all for attending, and a big round of applause for our speakers for such excellent and enriching contributions. Please keep an eye out for our future webinars through our social media and our newsletter. And have a lovely evening, day, morning, afternoon, wherever you are in the world.